All right, let's get back on the record in the state of Texas versus Karen Diona Villegas. We are outside the presence and hearing of the jury. I left copies of the court's charge after we talked about it off the record last night, or maybe it was on the record, I don't recall. Has the state had a chance to review the new charge?
Yes, Your Honor.
Is there any objections or additions?
No objections to the state, Your Honor.
All right. Ms. Ponzu, Mr. Roberts, have you all had a chance to read the court's charge to the jury?
Yeah.
Are there any objections or additions?
No.
All right. Okay. I know the state is going to divide their time. Who's going first?
I'm going for it, Your Honor.
All right, Ms. Lewis, what kind of warning do you want to have?
I'm leaving 15 minutes and I was going to 1 hour and 5.
And,
I mean, when I have 5 left.
okay.
When I have 5.
Well, same thing. All right, 5-minute warning. I'll just say you have 5 minutes.
Thank you.
All right, Ms. Bradford, what kind of warning would you like?
May I have to say 1 minute?
All right. And will the defense divide their time?
Yes.
Okay, who's going to go first?
I will.
Mr. Roberts, what kind of warning would you like?
If you could get a 2-minute warning,
Well, how much time do you want to use?
12 minutes.
All right. I'll get my stopwatch out.
Thank
And Ms. Ponzu, for the remainder of the time, how much of a warning do you want?
You can tell me when I have 5 minutes left.
All right. 3 minutes.
Sorry,
That's all right. That's all right. Everybody does it different. That's why I write them down. You're welcome. All right, we're just waiting on our juror. It's okay. Thank you. Okay, great. All right. Well, let's bring the jury in. Oh, did you need anything? Everything okay? All right. Yes, absolutely. Yes. We're ready.
All rise.
All right, you may be seated. Ladies and gentlemen of the jury, good morning. All right. Now that the state has rested in rebuttal, do both sides close?
Defense closed, Your Honor.
All right. We have now reached the close of testimony, which means that you've now heard all of the evidence that you're going to in this case. The court has prepared the court's instructions to the jury. This contains all of the law that you are to apply to the evidence in this case. I will now read this to you, and this will go back into the jury room with you, so you don't have to memorize it. After I read this, we will have arguments of counsel. Court's instructions to the jury. Members of the jury. The defendant, Karen Gallona Villegas, is charged by indictment with the offense of compelling prostitution, alleged to have been committed on or about the first day of April 2019 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. Applicable law. A person commits the offense if she knowingly causes, by any means, a child younger than 18 years to commit prostitution, regardless of whether the person knows the age of the child at the time of the offense. Term definitions. Prostitution occurs when a person knowingly offers or agrees to receive a fee from another to engage in sexual conduct. Sexual conduct includes deviant sexual intercourse, sexual contact, and sexual intercourse. Deviant sexual intercourse means any contact between the genitals of one person and the mouth or anus of another person. Sexual contact means any touching of the anus, breast, or any part of the genitals of another person with intent to arouse or gratify the sexual desire of any person. Sexual intercourse means any penetration of the female sexual organ by the male sex organ. Fee means payment or offer of payment in the form of money, goods, services, or other benefit. Mental state definition. A person acts knowingly or with knowledge with respect to the nature of his conduct or with respect to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware of his conduct, when he is aware that his conduct is reasonably certain to cause the result. Date of offense. The indictment alleges an offense to have taken place on or about the first day of April 2019. With respect to the offense of compelling prostitution, the state is not required to prove the exact date alleged. On or about means any date prior to June 6th of 2022, the return date of the indictment. Application of law to the facts. Compelling prostitution. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that the defendant, Karen Gallona Villegas, on or about the first day of April 2019 in Dallas County, Texas, did unlawfully then and there knowingly cause MP, a person younger than 18 years of age, to commit prostitution, you will find the defendant guilty of the offense of compelling prostitution as charged in the indictment. If you do not so believe, or if you have a reasonable doubt as to the defendant's guilt, you will acquit the defendant and say by your verdict, not guilty. Presumption of innocence and burden of proof. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. In all criminal cases, the burden of proof is on the state, and it never shifts to the accused. The state has the burden of proving every element of the offense beyond a reasonable doubt. The state is not required to prove that a person is guilty beyond all doubt. The state must exclude all reasonable doubt about the person's guilt. If it fails to do so, you must acquit the defendant. Extraneous conduct. Excuse me. You are instructed that you may not consider the defendant's commission of crimes, wrongs, or acts not alleged in the indictment unless you first find and believe from the evidence beyond a reasonable doubt that the defendant committed such crimes, wrongs, or acts. Even then, you may only use that evidence for the limited purpose for which it is admitted, as instructed below. You are instructed that if there is any evidence before you in the case regarding other crimes, wrongs, or acts committed by the defendant against MP, you may consider such evidence for its bearing on relevant matters, including the state of mind of the defendant and MP, and the previous or subsequent relationship between the defendant and MP. If there is any evidence of other crimes, wrongs, or acts committed by the defendant, you may consider such evidence in determining the motive, opportunity, intent, plan, preparation, knowledge, absence of mistake, or lack of evidence of the defendant, and for no other purpose. Fifth Amendment right. Every defendant has the constitutional right to remain silent. A defendant may testify in her own behalf if she elects to do so, but this is a privilege accorded under the law, and if she chooses not to testify, that fact cannot be held against her. In this case, the defendant has elected not to testify, and you are instructed that you must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Instruction regarding bias. You are instructed that jurors must be able and willing to make careful and impartial decisions that are not based on bias or prejudice. Do not let any personal bias, prejudice, sympathy, or resentment on your part, or any such personal emotion on your part, enter your deliberations or affect your verdict in this case. All persons deserve fair treatment and equal justice under the law, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You must set aside your own personal biases and prejudices during your deliberations and base your verdict on the evidence. Decisions based, either wholly or in part, on unfair stereotypes have no place in a criminal trial and will taint any verdict which is not based solely on the evidence and these instructions. Evidentiary instructions. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. Therefore, you are instructed that the indictment in this case cannot be considered by the jury as evidence of guilt, if any. You are instructed that any statements of counsel made during the course of this trial or during argument not supported by the evidence or statements of law made by counsel not in harmony with the law as stated to you by the court in these instructions must be wholly disregarded. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. You are not to be concerned with the reasons for such rulings, and are not to draw any inference from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you must not consider the same. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been, or as to the reason for such objection. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, you must wholly disregard it. Deliberations and verdict. You are instructed that it is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror what he may have heard regarding the case from any source other than the witness stand. You may not use any electronic means or device to communicate about or research the issues, facts, or law in this case. You should neither consider nor mention any personal knowledge or information you may have about any fact or personal connection. That's a typo. Or person any fact or person connected with the case, which is not shown by the evidence. In deliberating on this case, you are not to refer or discuss any matter or issue in evidence not before you, nor talk about this case to anyone not on your jury. You are the exclusive judges of the facts proved, the credibility of the witnesses, and the weight to be given the testimony. But you may only receive the law from the court, which is given to you in this charge, and you must follow these instructions. After you have retired to consider your verdict, no one has any authority to communicate with you except the officer who has you in charge. During your deliberation, if you need to communicate with the court, please press the red jury call button. Your communication with the court must be in writing and signed by the presiding juror. The court will answer any such communication in writing. No one else has any authority to communicate with you during your deliberations. Do not attempt to talk with the bailiff or the attorneys regarding any question you may have regarding the evidence. After arguments of counsel, you will retire and select one of your members as presiding juror. It is the duty of your presiding juror to preside at your deliberations and vote with you in arriving at a verdict. Your verdict must be unanimous, and after you have arrived at your verdict, you may use one of the forms attached hereto by having your presiding juror sign the particular form that conforms to your verdict. Signed by me, Nancy Mulder, Judge of Criminal District Court Number 6. Now, the very last page has the verdict forms, and you have to choose one. We, the jury, unanimously find the defendant, Karen Gallona Villegas, guilty of compelling prostitution as charged in the indictment, and there's a place for the presiding juror to sign and print his or her name. Or, we, the jury, unanimously find the defendant, Karen Gallona Villegas, not guilty, with the presiding juror signing and then printing his or her name. All right, we will now have arguments of counsel. Will the state open?
Yes, Your Honor.
You have 15 minutes.
Thank you. You're ready for 5 minute warning?
Yes, ma'am. Yes.
May I please report? defense counsel, and ladies and gentlemen of the jury, thank you for your time and your attention and your participation. I know that we're here talking about a very touchy subject. I know that you've heard a lot of things that maybe shocked your conscience, shocked your mind. I know you all have things to do outside of this court building. I know that this took you away from your friends and your family, but I also know that this is very important. It's the most important day for Marvin and her family, and I'm sure they are so grateful that you are for your time and attention. Listen, I talked to you on Monday. I don't know if you remember, but we had a long conversation about compelling prostitution. Y'all remember that? And I went over the elements of what a compelling prostitution case looks like. And what I am going to do for the next 15 minutes, and I'm going to try to get some time back, is to go over those elements with you and just remind you of what we talked about and what the law is. We talked about the defendant. The state has to prove the defendant on or about a certain date in Dallas County, knowingly caused by any means a child under the age of 18 to commit prostitution. That's what we talked about. And so what I am going to do is go through each and every one of those elements and apply the facts that you heard from this witness stand so that at the end of this argument, you will know beyond a reasonable doubt that this defendant is guilty of compelling prostitution. I want to first talk to you about Dallas County. So, do you all remember Detective Brandy? He took this stand. He is an expert in human trafficking investigations. And he told you that here in Dallas County, human trafficking is a huge problem. It's a problem in the country, it's a problem in the state, it's a problem here in Dallas County. You remember he told you that this year, Dallas County was #1 in Texas for recovering victims. He told you that here in Dallas County, out of all the victims recovered, out of all the cases that we have on human trafficking, familiar trafficking is 1/3 of the problem. He also told you that family trafficking is very hard to prove. And I submit to you that after hearing testimony this week, you understand why. He told you that defendants usually are the mom and the dad. He told you that the lead, the person who does most of the work, is usually the mother figure. He told you that the dad is somewhere behind the scenes. You remember that testimony? He told you that the mother usually finds someone in her social circle. And he told you that usually the victim is so loving and loves that mother figure and that father that she is loyal, that she loves them, that she trusts them, and so she doesn't tell. He told you usually there's a benefit, and that benefit is usually money to help the family or drugs. And ladies and gentlemen, what played out in this courtroom exactly is what Detective Brandy told you. The evidence in this case from an expert witness who goes all around the state of Texas investigating these cases lines up exactly with this case. And I don't want you to be shaken by tears. I want you to focus on the facts. Because when take her, she has nothing to lose. She's not a virgin. Came from this woman's mouth. Take her for money. There were no tears involved. Take her. You can have her. There weren't tears exchanged. Don't be motivated or moved by the tears. This 33-year-old woman who's birthed 9 kids, one of her child sits right there as a 14-year-old, has access to how many other little girls in her family. This 33-year-old mother, I submit to you as a master manipulator. You heard from 3 of her loved ones who told you they love her, that they can talk to her about anything, that she serves as a best friend to them. You heard Margaret tell you she loved her. She trusted her more than she trusted her mother. Why am I telling you that? She has a hold on young people. And you heard a term called grooming from the expert this week, Holly Dotson. And that's exactly what this defendant does. She grooms young girls for the benefit of money and drugs. You heard her own daughter tell you she had to ask her mom to stop smoking marijuana at 9 years old. When you judge the credibility of these witnesses, don't forget what you heard. This defendant, 27 years old at the time of this offense, knew exactly what she was doing when, at 13 years old, she finally tells Marva that she can come and live with them. Do you remember the testimony? Marvin and her siblings were not allowed to go live with Dad, and then suddenly the defendant and her husband decide she can come move in with them. And Marvin tells you she starts using alcohol. She already smokes weed, but she starts drinking alcohol at the age of 13. Who is she drinking with? This defendant and her dad. They provide her with alcohol, drugs, no rules. They allow her to do anything she wants. The other thing that you know, after hearing from the expert in this case, she tells you that Marvin is the perfect victim because she is a troubled teen. Remember that? I wrote down what she said. She said, Polly Dotson said, people with behavior problems are easy targets because perpetrators think people won't believe them. So yes, we know Marvin was a behavior problem. We know that. And perpetrators perpetrated on the fact that people won't believe her. And we're asking you to believe her. We already talked about this on or about, and all 12 of you, 13, told me that you understood what before the date of the indictment meant. So you're going to probably hear from defense counsel. She's going to argue about how we don't even know the dates. You have the law that's coming back to you, which tells you as long as the offense happened before the return date of the indictment, that's all the state has to prove. The return date in this case is June 1st, 2022. What you know is this offense occurred between 2019 and 2021. Caused by any means. You heard the testimony. You heard that this defendant allowed Marvin to live with her. This defendant actually provided from her social circle the people who would sexually abuse Marvin. You heard that this defendant told Marvin how much to charge. You heard that this defendant benefited from the money by getting cocaine, clothes, and money. You also heard this defendant drove Marvin to the dates, took Marvin home. You also heard that this defendant called and spoke with the men who sexually abused Marvin. You heard that she was the brain and the mastermind to this prostitution, this compelling prostitution of a minor. Any means. Remember the conversation we had about any means? Any means means any means. The state has proven that element. You also heard, we talked about this in voir dire, a child in this case. A child is anyone who is younger than 18. We know that Marvin was 14 and 15 years old. So the state met that element. And then we talked about who is a perfect victim for this offense. I tell you that Marvin is a perfect victim. And this defendant is counting on you all not to believe Marvin. And I want to tell you, you may not agree with the state allowing the defendant, Samuel, to plead. But because this case was far more important, this case was so important, for you to believe Marvin was so important. Yes, he received a deal of probation. Yes, he will have to live out his probation. You heard all the conditions of his probation. But what Samuel did was, he let you know that everything Marvin told you, you can actually believe. He told you that it was this defendant who told him, take her. She has nothing to lose. She's not a virgin. This defendant take her for money. You heard him tell you that. You told him how, you heard him tell you how he tried to take her.
You've used 10 minutes.
Thank
counsel.
you, Your Honor. She may not be someone that we would want our children to hang out with at 14 or 15, but she told you the truth. And there's enough evidence for you to corroborate what she said. She told you the truth, and we're asking you to believe her. Not like her father, and not like every other adult in her life, besides her mother. Believe her. You also heard that prostitution, and it's inside of your the charge, for a fee. That fee can be cocaine, that fee can be money. So when this defendant set Marvin up to sleep with motherfucker, and they received more cocaine and money, that is a fee. Witness credibility. You guys, you are the sole judges of who's telling the truth. What is the truth? You can believe all of it. You can believe none of it. But please, hear me when I say, conflicted testimony does not equal reasonable doubt. If you heard two witnesses take the stand and they gave a different account, Holly Dalton told you about how certain people remember certain things. Remember she talked about the shirt and the shooting and how somebody will remember one thing, someone will remember something else. Conflict in testimony does not mean it did not happen. And I will tell you, the fact that the witnesses that the state provided you did not get up here and tell the same story makes them more credible because they did not rehearse their stories. They didn't rehearse their testimony. They told it as they remembered it. What motive does Marvin have to lie? She told you she did not want to testify. When the state prosecutor direct examined her, it came out on the stand that she had to be picked up on Monday because she would not show up for court. So this story about her getting a house for testifying, about her talking to Jennifer in 2024, who has the motive to lie? Who has the motive to make up a story? Does that make sense? Marvin hasn't talked to her daddy. And they want you to believe that she's going over to this defendant's mother's house. Who has the motivation to lie? Also, Jennifer wants you to believe that Marvin was playing dolls in 2014 and in 2019 when she was 14 and listened to Taylor Swift. When you heard the counselor, you remember the counselor from the middle school? She told you this young lady couldn't even focus in school. She shut herself inward. She would have to sit in the counselor's office when she was in 8th grade. That does not make sense, what Jennifer told you. And you get to decide why. Who has the motivation to lie? You decide who's credible. Conflict in testimony does not equal reasonable doubt. At the end of the day, I suspect defense counsel is going to get up and make a huge deal about the fact that motherfucker, Augustine, and Cumbia were not charged. If you take issue with how this investigation was run, take that up with Dallas Police Department. Please do not hold that against this young lady. The fact of the matter is the state has proven each and every element beyond a reasonable doubt, and one of those elements is not who was charged for this offense. Do not think about that 1 minute. And if you do, take that up with the Dallas Police Department. What we are asking you to do is review all the evidence that was presented on this stand, and we are asking you to hold this mother accountable for her actions. Accountable for every cut this young lady put on her hand. Hold her accountable. This young lady took this stand, and 5 years later, she still cries when she tells that story. I thought this lady loved me, and when she told me she wouldn't allow her daughters to sell themselves, I knew she didn't love me. master manipulator. And we're asking you to find her guilty of compelling prostitution of a child.
Mr. Roberts.
Okay, please report. Council for the state. Ladies and gentlemen, here. How are y'all doing? Good. Okay. I know it's been a long week, and it's a lot to take in. But I can't tell you how important it is the job that you're doing. I told y'all on Monday. I know Monday seems like an eternity ago. When you sit in these seats, which are a lot more comfortable, as I promised you, in those seats, when you're waiting in the back trying to figure out what we're doing, hopefully you all see that some things just aren't so black and white. And when I say they're not black and white, it's not so easy. It's not easy to do my job. It's not easy to have to take on the responsibility of understanding that a mother of 8 children's life is on the balance. A 33-year-old mother. Karen is not some evil, hard-nosed, out to get it criminal. She's not. She's a mother of 8 kids. She's got a big family. We could have called family members all day. You guys heard from Jennifer. You heard from Carla. You heard from Diana. This family loves each other. Karen loved Mark. It's hard to separate what's fact and fiction. And I say what's fact and fiction, and it's what's very frustrating about this case. And I'll tell you, actually, before I go there, I'm going to come back to it. But I want to talk to you just a little bit about this jury charge. So this is the law that you have to follow, that the judge gave. This jury charge is about 6-7 pages long. You go back there, you read through it, you sort through it. You got to choose a foreperson. So one of you all are going to be in charge in the back room. You're going to kind of have to be the person to say, how are we going to do this? And that foreperson is the person who's going to be responsible for signing the last page, the verdict. You'll be called also the presiding jury. So you'll kind of, however you decide as the foreperson, it's a huge responsibility. You decide how to go about doing it. I'm just kind of talking procedure. You all don't have to agree on anything. You came in here with common sense on Monday. You got to hear some other folks' common sense. And so you don't check that common sense when you go back to the jury room. What you do now is you got all the facts on this case. And I say all the facts that are relevant to this specific case. And then you're given a law. And you apply the two together. And when you do that, I think relatively easily, what you'll be able to do is decide that that second line, we, the jury, unanimously find Karen Villegas not guilty. You will be able to do that. And so then the next question is why or how. So the chart that I have up there on the screen, we look at this on Monday. What it takes to get you in this seat to get indicted is probable cause. And you see where that's at. Ask yourself when you go back there, has the state proven their case beyond a preponderance of the evidence? Clear and convincing evidence? Or have they proven it beyond a reasonable doubt? Is it so cut and clean where you know for sure, beyond a reasonable doubt, that this happened? And I'll submit to you it's not. And it's not because of, the truth is, the state said, take it up with Dallas Police Department. How exactly do you go about doing that? Do you write your city council person, write the commissioner's court, set up a meeting with the police chief? Or since the Dallas Police Department investigates cases in Dallas County, and those cases come to the Dallas County DA's office, you hold the Dallas County DA's office responsible for the investigation that the Dallas Police Department either does or doesn't do. And so when we talk about this case, think about the folks that are missing. Like missing in action. Ebola. Where is Martin? Sounds like he's in California. Are they looking for him? Did he compel prostitution? Did he receive some benefit or some type of cocaine at some point from somebody? I didn't hear Detective Romano say that he put a warrant out for Martin. I did not hear that. And if you didn't hear it, it didn't happen. Detective Romano started his investigation in June of 2021 and concluded that investigation. He got a warrant for Karen in August of 2020. I didn't hear motherfucker, Augustine. I didn't hear warrants for their arrests. They had sex with a child. Allegedly. And I say allegedly, I wasn't there. I don't know what happened. And what I do know is if you would have brought him in and cut a deal with him, because they cut a deal with this guy tried to have sex with a child. Samuel, he's not even part of this investigation. And so I don't know what these other potential folks who should have warrants for their arrest, we should take up with the Dallas Police Department. And I understand Detective Romano and Detective Grandy there are overworked and underpaid. Child exploitation unit, crimes against children, expert witnesses, large investigations. Detective Grandy was pretty clear about this not being, this type of case is not a priority one case. Priority one is an active missing child or an active trafficker in town. It just didn't fit. What I want to know, and hopefully it's clear to you all, is where are the bad guys? Where are the people who are out sexually assaulting, molesting children in this town? They created these poster boards. All these folks who are, this guy here, Cumbia, Hector, that's Samuel's brother. That's what I heard. They saw him. Samuel just saw him 6 months ago. In your community, where's his accountability? Where's the warrant for his arrest? Where's the deal for him? Where's the trial for him? Where's the responsibility for him? Make him a registered sex offender. Make him a registered sex offender. Make him a registered sex offender. Make somebody on this board that's having sex with children a registered sex offender. We don't do the system any justice if we fall short of holding the folks that we think are accountable by cutting a deal for probation with somebody who doesn't have a registered sex offender. Now, we talked about types of evidence that you would see, may not see, or would want to see. We talked about, would you want to see a complete investigation? A full prosecution. And I understand time is limited by the Dallas Police Department. But we got to assume everybody's a suspect. When you show up to Augustine's house and you talk to a guy, who is that guy? Jamie. He was roommates. So was Jamie a co-conspirator with this other guy? They could have brought him in. That apartment was leased by Alfonso. They could have brought him in. They could have got that lease agreement and tried to do some more digging so we can actually have something, if there is something to believe. However, we're left in a position where we have to defend a mother of 8 who's 33 years old, who got involved in a romantic relationship with Martin, who obviously is in California and has left Karen here to sort this out by herself. And I'll submit to you, Where's the physical evidence? Where's the scientific evidence? Where's the stuff? The stuff that you're going to base your verdict on. And I anticipate what the state's going to get up here and say is that you don't need all that stuff. All you need to do is listen to Marvin, believe she's a traumatized youth, which I agree, and that's enough. Listen to Marvin, believe she was traumatized, and that's enough to convict Karen of compelling prostitution.
You have 2 minutes, counsel.
Thank you, Your Honor. You heard Samuel testify yesterday. He was never offered any money by Karen. Given any money? He never gave Marvin any money. He never gave Karen any. Outside of Marvin's testimony, I don't think there's anything else to support that Karen is responsible, directly or indirectly, for Marvin's actions. When Marvin showed up at Karen's doorstep, Marvin was already traumatized. She was already a middle schooler using drugs. What happened is when we got to April, May, June of 2021, the world got heavy. And Laura needed an out. And Marvin needed an out. Years later, then when they say all this stuff happened. And that out was to out Karen. And what I would submit to you, you have an opportunity to return a verdict in this case of not guilty. You won't only, you won't fix the wrongs that are done. You can't fix the wrongs. You can't fix the pain, the agony, the support system that Karen has had to try to have in place as she fights for her life. You won't be able to fix that. But what you can do is you can send a loud and clear message, not only to these prosecutors here, but the entire Dallas County DA's office and to the Dallas Police Department over there, and let them know we expect more, we demand more, and if you give us more, we'll do the right thing. But if you don't, we're going to do the right thing. And so just because a case comes to trial doesn't mean somebody's guilty. You all talked about earlier in Ward Iron, what if you didn't know? What if you weren't sure?
12 minutes.
Thank you, Ron. What if the pieces didn't add up? What would you do? And you all told me, loud and clear, you would return the verdict of not guilty. Ladies and gentlemen, I'm doing nothing more than asking you to do what you told me to do when you took that oath. That if it didn't all make sense, and you couldn't put the pieces together, and you weren't sure, find Karen not guilty, and send a message loud and clear to the Dallas County DA's office and to the Dallas Police Department that they're going to need to bring you a better case. And what they're going to do is take a mother of 8 away from her children. Thank you.
Responsive.
Good morning, you guys. You ever been a kid and watching your, excuse me, your grandmother and your mother cooking in the kitchen? And she'd be messing with the stove, pots and pans. When she was creating the most delicious meal, your favorite little spaghetti, meatloaf, mashed potatoes. And you're in that kitchen watching it, knowing she's going to have this fabulous meal. And you're eager to help. You want to help. So you want to get up there, touch the pots and pans and the stove. But you said, wait a minute. You can't just do that. Because there's some rules before you start cooking. And if you're not careful, if you don't follow the rules of what I'm telling you, the wisdom that I'm giving you, you can burn yourself. You can hurt yourself bad. You can burn the food that you like so much, and you can burn this house down. Y'all are going to get y'all's chance to cook. This is the kitchen. And we've been doing this. We know the rules. Before you start cooking, before you start deciding things, before you start messing with the stove is the law. We need you to abide by the rules, because if you don't, you're going to burn the house down and go all in. It's no coincidence, guys, that the judge spent an hour or more of what about talking about the same thing as the state and the same thing as the defense. We've been in this kitchen cooking for a while now. And if you're going to come along and cook with us, there's some rules that are in place. And you have to take them seriously, because we know you're eager to help. So I need you to go back to your diary and remember that presumption of innocence that's given to Miss Gaylon over there with her head, where they said she's innocent until proven guilty beyond a reasonable doubt. Sonny yelled and she told you, hey, we are the state and we have to prove our case beyond a reasonable doubt. And if we don't, we didn't make it. We know what our burden is. And she said it because we know that it's important to follow the law. So their burden, guys, you see that stair step is proof beyond a reasonable doubt. That goes past clear and convincing. And I argue to you, you don't even have a clear, convincing element in this. I mean, it's not clear. But that's the burden we need you to remember when you go back there. Don't violate it, because it's the same thing that protects you, that protects me, it protects everybody in this courtroom when they got to be in the front room, when they're in the hot seat. That Fifth Amendment right a person has not to testify. When you get back there in that jury room, y'all can't even talk about whether she testified or not, because it's not something that you can consider. The judge is sending you back with instructions so you can be reminded of what the law is. And in here it says the state must exclude all reasonable doubt about the person's guilt. The other thing that says is it's not a sympathy part. It's on the very next page. It's not a sympathy part. Because I know when you see Marty, I want to get her. But we're going to have to go home and we got to pray on that one. Or hopefully the state can get her Miss Dotson's phone number, because you know when she sits up there, something's happening. That's a traumatized young lady. When she came and when Karen decided to open up the door and try to be a mother figure, this is somebody who already been cussing out her mom, sneaking out, smoking weed at 12. And when you get them mad, because she's 19, just graduated. When she was 12, y'all, she's in fifth grade. You tell me where you're sneaking out to in fifth grade. You tell me what other fifth grader you could be hanging out with. What other fifth grader's mom is opening up the door to you to say, hey, come on. But we know she's out later, a young lady. When we think about what we have to consider, is the credibility of the cases. That was states arguing like, hey, if you believe them beyond a reasonable doubt. So let's break it down. Let's look at Marvin, this hurting young lady. And we know that hurt people. A young lady that doesn't want to be there, whose statement is very consistent with Jennifer's, somebody's forcing you to do this. Is she being honest with you guys? We want to help, we want to know. But there's few things that you can look at when you go over her testimony. Some things that you're like, wait a minute, she's not going to be honest about that. What else is she going to lie? Like her pregnancy. You got to remember the first time you get pregnant as a young lady, a teenager, a minor, and you got to go tell your mom, or your mom finds out when you're pregnant. That was some conflicting testimony. My mom said, well, she denied it. She denied it up until the day that I took her to the doctor's office. She sat up here and told me no. Me and it's Isaiah or whatever her father's name is, we went and we told her. She flip-flopped all over the place on the boards and who she told. Oh, I told they had to constantly remind. I'm like, tell me everybody you told. Then they go back and told Ashley too. Oh yeah. She couldn't remember those things. When you go back and you look, when you got Detective Romano on the stand, and he told you about her forensic interview. We started off real low and once there's suspect here. Then all of a sudden, well, I'm like, how many people committed the crime? Then he had 3. Motherfucker in Augustine. There was no Samuel, guys. There was no Julia. Those are things that got it added on later when they're trying to make a case against Karen. And look who they picked up. Said, well, this is a 49-year-old man still learning how to spell his name with an elementary education. And even though he might not be the sharpest tool in the shed, he had enough sense to say, you know what, I'm going to say that I'm not going to part on your girl. For 6 years deferred, I get to go home to my warm bed, go to sleep with my family. No registration as sex offender, no prison time, and who knows whether he did it or not. But what you do is that it's hard to sit in the hot seat when you're accused of something. He's not sitting up maintaining his innocence with 12 jurors who could fry you. This woman's sitting here with her head down because she got a 50% chance. Y'all don't know her. That's why that law that protects you and me is so important. Proof beyond a reasonable doubt. Look at their inconsistent testimonies. When Miss Dotson, she cares. I care about the children. But she talked about, yeah, you can add on these things, but you don't have all these inconsistencies. She was inconsistent all over the place. When did you start cutting yourself? One day it was like you was 12. The next day, the state has to remind you, no, it was 14 when you got in your dad's house. Where she lived. Y'all, her mother, that was a witness. Oh, she's been calling her son a bastard, and he knows. He's like, I knew about that. I'm just happy that when I was trying to figure life out, somebody was trying to accept me for who I was and let me plan their makeup as long as I asked for permission because she had rules. When did you tell your brother Jeff? He said, well, you know what? I told her the next day. She was like, well, I told him at my dad's house. These are inconsistencies. These are things that you're not going to forget. And then, where did the girl live, for crying out loud? Her mother didn't know. Her mother sat up here like they have this close relationship. This girl just graduated from high school. You don't know where your child is? She didn't live at home her senior year. I'm like, where'd you live last year? She wasn't at home her junior year. All we know is that she lived with some man. Somebody who could probably get in an apartment. You got to be older. You got to have a job. This is probably a grown man. She's exposing herself to. So that she can earn a living. So that she can have something. And she's been doing it. That's what everybody's trying to say. This girl's sneaking out. She's coming up with money. And then when you get pregnant, and when your mom's looking at you, all of a sudden your mom takes you on May 22nd of 2021, finds out you're pregnant on June 1st, the following week. That's like Thursday to a Tuesday, the following week. You got your son running to school. We're going to get this one. We're taking somebody down. I'm pissed. And they all pissed. Because they feel like, oh, Karen's taking away my daddy. You heard it straight out of his mouth. What's your problem with Karen? She taking away my daddy. When did she start crying? Karen told her I wouldn't let my daughters prostitute. That little girl back there told her, I told my mom. And my mom had to let her go. She said, you can't stay in my house. And from the beginning, she said my mom knew she was a problem, but her daddy said she needed to stay, so she opened up to her. That's what got her. And now we're trying to make a case for Samuel. Samuel's case, guys, she accused him of something supposedly that happened in July of 2021. Do the math. That's reasonable doubt. July 2021, but he's telling the school, so you know Karen's not around. On June 1st of 2021, which is before this whole Samuel thing, Samuel's like, yeah, this lady told me, and Samuel, he'll go all over the place. Because really, Samuel just trying to get out of this courthouse. I tell them something, yeah. They tell them something, yeah. Whatever you want me to say. Did you see him green when I was like, you got a good deal? Like, you got, he was like all I got to do is be here, get through this, and I'm on to the next. We don't even know if Augustine is a real person.
You have 3 minutes now.
Because the detective, they didn't do their job. Motherfucker could be sitting right here in this courtroom right next to Augustine for all Detective Romano knows. It's like, well, with a person, Jamie, he could have been motherfucker. She depended on her who said, well, I heard they called him Enrique one time. Why don't you take that picture that you at least got or that you found in your database, put it in the lineup and say, hey, is this the guy? Just so you can make a better case against Karen? Who's over? You gonna lock her up over this? No, you tell Dallas County you're not doing the dirty work. You come to me, you prove your case beyond a reasonable doubt. You do your job, Detective Romano. You don't do that because it's a child. They're saying she's right. There's somebody over there in the hot seat that can go to prison with 8 kids. The burden is hot, and nothing is even clear and convincing in this case. The state knows they're burdened. And if you don't follow the laws before you cook in this kitchen, we all burn. Because if anybody ever gets accused of a crime just off one person's accusation, and you lower that bar, we fry. You're not doing the better work. And I'm going to ask you to make sure that when you go back there, you try to stay on and not guilty. Thank you.
Miss Bradford?
May it please the court. Defense counsel. Where are all the bad guys? Members of the jury, this entire week, one of those bad guys has been sitting here, right in front of all of you. During this trial, you learned that it's love and loyalty to the family, to this defendant, that makes these cases so hard to detect. And it's this defendant that used Marvin's love, her loyalty, her trust, confiding in her in a time in her life where she wasn't getting along with him. And she used that, she exploited it, and she compelled that 14-year-old little girl to prostitute. Think about that for a second. This defendant was around the age of 26, 27 at the time, and she was the stepmother of that child, and she compelled her to prostitute herself. She was in middle school. Now, you all heard when Marvin took the stand, and through tears she told you that she felt disgusting. What's disgusting is what this defendant made her do. And there is no room in our community for compelling prostitution of a minor. Now, defense counsel, I want to acknowledge that they did a great job representing their client. They zealously advocated for her. But what they focused on was all of these other outside things. They talked about how Detective Romano, he needed to find all of these individuals. And you can rest assured that if there is more forthcoming information, they will get their day in court. But that's not why you're here today. You're here today to assess this defendant's crime. They tried to discredit Marvin. They put on witnesses to talk about how she was disobedient. She would curse and she would sneak out of the house. They tried to focus your attention on the fact that she couldn't remember what school she was at, what grade she was in. It doesn't matter because we all know she was under the age of 18 when this was going on. They're trying to distract you from what their client did. They tried to attack Laura's credibility by saying, oh, she's jealous because this defendant with her ex-husband. But you all heard Laura. She's married with kids. She don't want her man. She's not jealous. She's a concerned mother who knew that when her daughter was over at their home, there wasn't structure, there wasn't rules. She was getting away with things that she didn't want her daughter doing. They want you to focus on everything but what Marvin testified to you when she took this stand. Not once did you hear them attack a single one of these instances. Not once. And you want to know why that is? It's because you can't attack the truth. Now, defense counsel says that the state wants you to rely solely on the testimony of Marvin. And under the law, you can rely on her testimony if you believe her and we proved all the elements through her. The law allows that, but we have way more than that. So let's talk about some of the corroborating testimony from other witnesses that let you know these instances actually happened. Let's start with Jeffrey. You all heard from Jeffrey. He gave you a distinct instance where he and Carla were outside of the home on Hudspeth, where he saw this defendant take his sister late at night. He couldn't go. The other kids weren't allowed to go. They drove away, and then when his sister came back, she went to take a shower, she was upset, and she had money that she didn't have before. That's corroborative evidence. That's not just Marvin's statement. He talked to you about how there were a couple of times where he and the rest of the children went with this defendant and Martin to go pick up drugs. He described for you the little baggies that he saw. Martin talked to you about the cocaine that the money was used for, that her dad had a cocaine problem. All of this is consistent with what Marvin told you. He told you about seeing her with a bunch of money. He talked to you about an instant where after he found her with that money, she then took him and a couple of the other kids to get some shoes. All of that corroborates what Marvin has already told you. Let's talk about one of the defense's own witnesses, Carla. Carla talks about how her mother would drive Marvin to different places. She called them her friends' houses. And you know what? She says just enough that won't get this defendant in trouble. She gets right up to that line of corroborating different things but she stopped just shy of what would make it occur. She had to be refreshed. Her memory had to be refreshed. But she confirmed the red car that Marvin talked about, that the family had. The car that they were in, where she was transporting her to have sex with these men. She couldn't remember the time she saw her stepfather using cocaine, had to refresh her memory on that. But then she did have to admit to you all that she did, in fact, say, and she promised to tell the truth in her forensic interview, that she saw Martin with white powdered substance under his nails. Again, it's all lining up. They want to talk about the puzzle pieces and everything not lining up. It's all there. And it's not just Marvin's work. It's this defendant's daughter's work. She also wanted to talk about how she would see Marvin with money, but then when I talked to her about a specific instance she talked about in the forensic interview, she wanted to back up a little bit on that. So she had to be refreshed on that. And then she had to admit that there was a time where she saw Marvin with $200 and that Marvin took her and this defendant to Devi's, and Marvin bought Carla a purse, a crop top, and this defendant a dress. All of those are benefits this defendant and her family were receiving at the hands of Marvin having to prostitute herself. Let's talk about Jennifer. She wasn't around as much. But she did tell you that there were times where she saw Marvin with wads of cash. But that she was so close, they were joined at the hip, but they didn't feel that it was important enough to tell an adult. Carla didn't feel like it was important enough to tell her parents, and these were supposed to be children that followed the rules. Well, isn't telling the truth a rule in that household? And do you remember what it was that Carla said why she didn't tell her mom what she thought Marvin was doing? Because she wasn't her sister. And that's exactly how Carla saw her. That's how this defendant saw her. They want to come in here and act like they were such a loving family and nobody was treated different. You heard it out of her own mouth. She told you, that's not my sister.
You have 5 minutes.
Thank you, Your Honor. Samuel, he told you about the time where his wife would have cookouts and Marvin would just go get the alcohol herself. And Karen and Martin are just there watching. No issues, no problems. But they want to pretend and act like their household was just so upstanding, that there were so many rules and that none of this would have ever happened under their watch. And then Samuel's testimony to you, where he had to admit what he did, and it aligned exactly with what Marvin told him. There are so many other people's testimonies that you can rely on that corroborate what Marvin told each and every one. This week, Laura Hernandez came in and she stood up for Marvin. Her brother Jeffrey came in. He stood up for his sister. Detective Romano, he came in. He had to own that. Sure, there's more things that could have been done, but he still came in here and he stood up for Marvin. Detective Brady, he stood up for Holly Dodson from the Dallas Children's Advocacy Center, stood up for her. Leah Clark, a teacher who used to be in our community, came back to stand up for a former student. and now the 12 of you have been excluded from that thing as well. You have the ability to say to this defendant that here in our community, in Dallas County, we don't tolerate compelling prostitution of minors. Members of the jury, Marvin has waited long enough for justice. Don't have to wait another minute. Find this defendant guilty.
All right, ladies and gentlemen of the jury, you will now retire to the jury room, select your presiding juror, and begin your deliberations.
All rise.
All right, you may be seated. All right, Mrs. Garza, let's go through the list. It's a short one. Yes. Mhm. Just make sure the bailiff has your phone number if you're going to be wandering. I'm going to go over the evidence with the court reporter, Mrs. Garza, and then we're going to send it back. Good morning. I remember her, Stella. Hi, Mary. Nice to meet you. That's her. Yeah. Well, we're going to send all the evidence back.
Oh, okay.
No. Do you want me to put you down?
If you want to, and file them up.
I thought this was going to be an that's turned into a mistake.
Oh, great. I am. I'm free now, so come on.
Okay, good.
Okay.
1, 2.
Yep.
3.
3, 4, 5, 6,
7, 8 are two diagrams, and then 9 is another one, 10, 11 is a chart diagram, and, oh wait, no, that was 10. Oh wait, 10 is a diagram, and then 11 through,
I have 10 as the second family tree.
10 is a family tree.
Okay.
And then 11 through 16 are diagrams.
Yes.
All those diagrams. And then 17 is
Age chart. 18 is another age chart.
19 defendant,
Mm-hmm.
20
It's record
it's
only.
record only.
Yes,
And
ma'am.
then 21
It's photo
is a
from
photo from the
2021.
Yeah.
And then 100 is for record only.
and
The
100 is
Michael Morton.
Yep.
And
So-
then defense 1 and 2 were not offered.
No, that's exactly what.
Okay. Perfect. Thank you. Yes, ma'am. I haven't had it. No. Huh. About.
So I thought
Mm-mm. Oh, there it is. Okay. I know. That's okay. Mm-hmm.
threatening the ex-boyfriend. She burned up the ex-boyfriend's mom's car.
Yeah.
So there was never no contact ordered. Well, now she's threatening her with all these pictures. Okay. Like burning up her car.
Okay, go.
Well, that's a threatening someone. Threatening property damage is a criminal offense. So why don't we
I don't.
put her in jail?
Jay said just add no contact for the mom or the boyfriend.
Well, I'm going to add, is she working?
It says she works at the CML Plasma Center.
I don't know where it went, but now it's in there.
They didn't put in the bench. They put no conditions
It was
on
not.
that.
It was not.
Well, she's going to have conditions now. And I'm going to yell at her.
The only thing she's doing is they have a new case also call it lunching adult caseload. She's going to that.
Well, she's going to do anger management. Okay, so she's going to do anger management and stay away, no contact. And I'll yell at her. Okay?
Okay. Yeah, she's on her phone.
Okay.
But yeah, the text is scared.
Okay.
She called the victim services. I can tell victim services to tell the mom to file a case.
Yeah, she needs to make a complaint. Okay.
Oh, was it submission to us? This is all the evidence. I mean, it's ready to go. I don't know if I still address it, you can have it. That's the thing.
That's the conditions.
Yeah, she has to wait. Or, yeah, I mean, as soon as you're. Yeah, you can have her. Okay, and then I'll admonish her. Yeah. What is her name? Okay, that's the one I have in my hand. Okay, so this mod order is no good then.
I'll add that. Yeah.
Okay, all right, because you're going to add anger management. Yes. Okay. Good morning, Jack. Good to see you. Yes, and Varun, if you want to come up too. Okay. Come on up. Okay, good. Thank you. I'm hoping the jury reaches a quick verdict.
Are you trying to punishment for that too?
Oh yeah, we'll go straight into punishment as soon as.
Even if they take free lunch?
Yeah.
So it's gonna be
Excuse me.
late
Yeah.
night for you guys.
Yes, it will. Okay. What questions do y'all have?
That was the first one. If you're gonna do punishment for this today
Oh
as
yeah.
well.
Oh yeah.
Is
We're
that
gonna
usually
keep.
what happens if it comes through Friday?
Oh yeah. We just keep pulling our oars, trying to get to shore.
Oh, yeah. At least you get the weekend, I guess. Yeah. And then, is it a dead weekend for next week?
Well, I'm leaving town Thursday morning for Rhett's IU orientation, so we're not going to be in trial, but I'll be here Monday, Tuesday.
Yeah.
Yeah. We're going to pick the jury the following week. What day of the week is that? Yeah, the 16th.
June 16th?
Yeah. Oh,
Cedric. Who's going to be visiting for you?
I'll be here on the 16th. I'm not going to have a visiting. I wrote that when I was going to take the week off. But then we had too much stuff come up. So now I'm going to be here Monday, Tuesday, Wednesday.
Court's not going to get blessed with Mike Snyder's presence?
No. Because I took a week off for graduation. So. Okay.
And then for like those, you swear the witness in and they have those motions in limine for witness testimony.
Yes.
So are those common for like non-expert witnesses?
Yes. Because that's like when you have a family member, friend get in trouble, and then everybody gossips about it, and everybody tells what they think about it or what they've heard. And then that person who may know one or two things comes to testify. But they've been told so much, you have to separate out hearsay compared to, you can only testify to what you personally saw, heard, or felt whenever you saw or heard what it was.
So when you're talking about the promiscuity of...
Yes, now that is called the Rape Shield Law that came into effect back when I was, back in my teenage years.
So is that under TRD 412, or is that its own?
That is the rule.
So TRD 412 is the rape.
Yeah, that's just what we called it.
Yeah.
The fact that promiscuity is not admissible, because that's what used to happen. Oh, he's a slut, so she was asking for it.
So you get typed in this.
Yeah, I had a question. Okay, so this is what I completely understand, like the intention of the
right.
It makes sense.
Right.
I'm thinking like in this instance in which the defense. I'm not allowed to talk about the details. Oh, okay.
Yeah, they're not here, so go ahead. Okay, well, let me stop streaming real quick.
Pretty important.
Yeah.
Do judges usually want to stream that?
No.